Hey everyone, Lauren Jones here. I am your estate planning and business law attorney coming to you from California. I am here to talk to you about blended families. So what is a blended family in my world? So a blended family is a family that has children from different marriages or relationships or anything else. And you guys are coming together and you're creating a beautiful life, and you have already created one most of the time. I'm talking to clients that have been together for many years and have had a blended family for quite a long time, but sometimes it's a new thing, so it doesn't matter one way or another. Estate planning in blended families is really important, and let me kind of explain to you why, because I don't think that people understand quite the consequences. So when two people get married, most of the time they own property in joint tenancy. So joint tenancy has a right of survivorship clause. So we have one person, and when they pass, they give it to the other person automatically. So most of the time they held their bank accounts jointly, they hold property jointly, and many times many of the assets pass to the spouse upon one spouse's death, which is great, right? We want that. But this is the consequences when you have a blended family if you don't do estate planning, okay? So I would suggest that you do estate planning before one person passes, but let's say you didn't do any and you were married and you gave everything to your spouse upon your death, and when that spouse died, they didn't do a trust, they didn't do any estate planning, and we went just by the intestate rules in the state of California. So it would just say that all of those assets would go to the last person's deceased children, because the stepchildren are not contemplated for. But everything went to the spouse. So the surviving spouse that got everything, it would go to their children upon their death, which would disinherit your stepchildren. And that's not what you probably wanted to have happen. But it happens so often because people just don't realize that if I don't make a plan, those people aren't going to be contemplated for. You may think they're your children, but they're not your children in the eyes of the law. So stepchildren are just not part of intestate succession. So for those reasons, you and your spouse should come together, like I said, right? I just said you want to come together before any of you pass. You want to come together and make a decision on where you guys want your assets to go, so that your entire family, your children, on both of your children and any joint children, get to share in your inheritance the way that you want and how you want it and how much you want it, and all of those things. You get to make those decisions. So every time I'm talking to a family that has children from different marriages or relationships, I'm just stress the importance of estate planning, because I often am talking to families when someone did get disinherited unintentionally, and it was never an expectation of the parents to do that, but they just didn't do the proper planning to make sure it didn't happen. And even if one spouse passed, it's not too late for you, okay? If your spouse passed and you had a blended family, you can still do estate planning to plan for those stepchildren of yours, and you can still do that. So you can still correct the situation, but it's just a matter of really understanding that the law does not provide for stepchildren if you do not have something set up providing for them. So that is kind of the quick and dirty of what happens when you have a blended family in estate planning. But every single family, whether you're blended or not, is unique, and definitely we should talk about what your specific needs are and how we effectuate those goals the most efficient way possible. So if you have any questions about your family, give us a call and we will help you work through that process. Thanks so much.